You're listening to the Subrogation Support Network, a podcast from Mathieson, Wickert & Layer, America's subrogation law firm, with dissemination of new developments and changes in subrogation law, as well as emerging trends and best practices. Here's your host, Ashton Kirsch.
Hello, everybody. This is Ashton Kirsch, your host with the Subrogation Support Network podcast. Happy to be back with you after a brief hiatus. Today, it is my pleasure to have my partner, Gary Wickert, and co-host on today's episode of the Subrogation Support Network for a fantastic and entertaining and educational conversation on expert retention, advice, tips, and tricks. Gary, how you doing today?
I'm doing good, Ashton. Good morning. Thanks for having me.
Thanks for joining. So let's begin by just jumping into it. So Gary, why is expert selection so important?
Oh boy. One of the big questions that our clients ask us when they send us a file is, all right, we have this auto accident, or we have a guy who chopped off his arm with a press, or he was injured and lost an eye with the tool. Do we need an expert? And the question to that isn't as automatic as some clients might think. Sometimes an expert is needed. Sometimes it isn't needed. Sometimes an expert is advisable. Sometimes an expert is not wise because a subrogation file is too small to support a $7,300 expert bill after testimony and reports and testing and inspections. So when you talk about experts and subrogation, it all goes back to the fact that subrogation has to be done cost effectively. In order to be done cost effectively, obviously you have to have a recovery. And there are, in fact, some cases where expert testimony is simply required. We refer to these experts as forensic experts. For example, I am listed with a number of expert databases as an expert on subrogation. They have a resume of mine. They have samples of trials I've testified in, depositions I've given, motion hearings where I've given live testimony around the country. And then people will call and say, what is your rate? We have a complex subrogation question, and the judge is entertained having expert testimony. So there are all kinds of cases where forensic expert testimony is needed. The word, I find this interesting, Ashton, because there's so many criminal investigation CSI series on TV that the word forensics has historically meant just scientific tests or techniques used in the detection of a crime. In other words, criminalistics. It's the application of science and scientific principles and methods to support legal decision-making in matters of criminal law. Over the past century, and no longer than that, over the past century, we have morphed into sort of a technocracy. When you go back to COVID and who's listening to which medical experts, or you're in a case and a jury is paralyzed because they cannot determine whether a product is defective unless they have an engineer in a suit sitting in the witness chair telling them that in his opinion, based on reasonable scientific certainty, that product is defective. That's become sort of the norm. You and I both receive a lot of water supply line loss cases where we are given a supply line and some investigator has looked at it and said, looks to me like, the joint here has worn and water was leaking through. Here's a video of water leaking through. This is obviously defective design. Well, that doesn't really tell us anything. It might be good fodder for settlement efforts. But in the end, if you are going to file suit in a case, you must always be thinking about a trial. Anytime you file suit, you must be thinking about a trial and convincing 12 men and women of a jury, or 6, by a preponderance of the evidence that you are entitled to recover. And experts seems to be the way to go. And in some cases, it's absolutely necessary.
I can say,
I know.
Gary, a
Yeah, go
lot
ahead.
of clients, just expand on that. A lot of clients when they're new sub adjusters, right? They're new to this industry. They don't handle a lot of product liability work. We'll get cases in where the client sends over, oh, here we go. It's a fire arising from a failed component part in an oven, right? Whatever it could be. Like, hey, look, it's so obvious. Look, it just happened right there. That's where it is. Slam dunk case. And we look at it and it's 2 years later and they never hired an engineer and they threw away the evidence. But they look at it, oh, it's obvious. Like, no, we need to step back. And that's where we need to make sure, and we train all of our clients and all of the new attorneys and anyone new to the industry to really understand that, sure, experts are not always necessary. But truly, on any products case, no matter how obvious it is, we still need an expert, an engineer, somebody who can look at that and give an opinion, because, I mean, it's not sufficient just to say, hey, look how obvious it is, right? You don't need to just prove origin. You will need to prove cause. And we can go into that in more detail, but I'll digress, Gary. Continue with what you were going into.
No, you're absolutely right, Ashton. Take, for example, a very common case that we receive, an insured motorhome or a brand new Ford motor vehicle is driving down the road and bursts into flames. And luckily, all the occupants escape with their lives, but the car burns to a crisp on the side of the highway. We see those cases all the time. Those cases are referred to us. Please subrogate against Ford Motor Company because their car is defective. And we always have a very similar response, and that is, well, number one, just because a car burns up doesn't mean that it was a defect from the manufacturer. It could have been something dealing with maintenance. It could have been a cat or something that climbed into the engine, or it could be, in the case of up in northern Wisconsin, mink would actually come and chew on rubber hoses in cars. They love to go up into the car engine because it's warm, and then hydraulic fluid or brake fluid or whatever leaks onto the hot manifolds and a fire starts. That isn't a manufacturing defect. So in most of those cases, yes, expert testimony is needed. If it's not there, you are most assuredly going to have a defense who's going to say, well, they'll have their expert, and their expert will say, well, it could have been this, 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 or this. And all of a sudden you have a lot of doubt on the part of a jury, and you haven't met your burden of proof by a preponderance of the evidence, which of course means a greater weight of the credible evidence. So yeah, experts have become almost indispensable. You mentioned an expert being necessary, and we will tell a client if we think an expert is necessary. We will tell the client what that expert might cost, what the budget will be, what that we think they will add to the case, and how much it improves the likelihood of recovery. And there are cases where an expert is necessary, but there are also cases, and this is just as important, where an expert is desirable. And what I mean by that is you might have a manufacturer of a water supply line who they may be in the middle of a product recall. Just because there's a recall doesn't mean that the supply line that you have in your hand and that caused your insured's loss has that defect. It could have been over-tightening, misuse, trauma. It could be anything. So an expert is desirable in a case where you want to maximize the settlement potential of a case. And you might be able to settle it for 20 or 30%. And a lot of our clients do that before referring it to us. But adding an expert into the mix now means that you have increased the settlement potential of that case exponentially.
Absolutely. So a huge part of this is finding out, step one, right? Do I need an expert? Looking at the dollar value, the facts of the case, right? The merits. From there, I think the next big question, and the hard thing for a lot of adjusters, both attorneys, adjusters, trained, new to the job, is really figuring out, who to select, how to go through this process. I know that a number of insurance carriers have kind of been moving towards this perspective of, oh, we'll use the same firm for everything, use the same engineering firm. use the same expert for all losses. And suffice it to say, my recommendation is strongly against that, right? We need to find the right expert for the right job with the requisite knowledge and experience, because the subrogation adjuster really needs to be an expert in selecting experts. You're the quarterback, right? You got that ball, you're calling the plays, and eventually you're going to hand off that ball, and you're going to have that expert pretty much run and hopefully score a touchdown for you. But you are still in control. You need to find and recruit the right expert for the right job through interviews. I mean, I always talk about, the idea that you can't really trust the CV. You can't trust the resume always. We've seen some experts out there who, Harvard educated, PE, doctorate, and this and that. And next thing you know, we put them on a fire loss and, we find out, oh, wow, they've never seen anything like this. They're used to handling water loss, whatever it could be. I have a case example that I use pretty often where, on our end, we'll take whatever case the client gives us, really in whatever form and review. But we prefer to retain our own experts. So bring us in early so we can hire the right people. But a number of years ago, we had a case where client retained their own expert. This is a firm that they had a contract with. So we had to deal with what we were given. And expert goes to the scene. It was an elevator failure. So, the elevator pretty much dropped down, crushed a guy working below it. Right. We took a look. It was the most obvious defect I've ever seen. The safety support bar was the size of my finger, holding up several tons of iron and metal. It needed to be wider. It was that straightforward. But the expert comes out, right? Retained by the client, thank goodness, and pretty much says this is a gang-related hit. It's a murder. And ended up being that the guy, I believe, was just a blatant racist. And it was based on the demographics of the area. And I had to fire an expert at the scene. We later brought out a new expert. We're able to actually reclaim and bring in almost 100% for the client down the road. But in the end, that case always reminds me, this expert, Stanford degree in engineering. Amazing resume. But if you call the guy up on the phone, you can tell, he kind of lost it. So we need to ask those questions. We need to call up our experts and make sure that we ask the requisite questions of, hey, have you handled this type of case before? Not just have you handled water losses, or not just are you a mechanical engineer or an electrical engineer, but we're asking specifically, have you dealt with this type of case? And if you haven't, why do you believe that you can? And I think that's important, right, Gary? It's kind of getting into the nitty gritty of the details rather than just, hey, an engineer is an engineer is an engineer, right?
Yeah, and it's interesting you mentioned, hiring the wrong expert or having an expert in your pocket, because many of our clients may recall an article and a PowerPoint presentation and a CE presentation that Matthiessen, Wickert, and Lair has done over the years called 10 Subrogation Mistakes That Insurance Companies Keep Making. One of those mistakes that we see quite often, and it can be devastating to subrogation cases large and small, is called subrogation and the Flat Earth Society, hiring the right expert. And what this mistake is that we have clients, in modern litigation, especially in subrogation, defective products cases, premises cases, negligent maintenance cases, or even medical malpractice cases, expert testimony may be necessary. And the first rule of subrogation is, clients, do no harm. And that rule is violated viciously when experts who are not qualified to support a subrogation claim area or an area of technology are engaged. That often happens when we have a massive fire and in goes a certified fire investigator and he writes up this report and it says, yes, it looks like the breaker box had not been looked at, inspected, or cleaned, and there was webbing and spiders and nests of mice in there, and it caused a short circuit, and this led to the combustion of combustibles next to the breaker box, and this spread to the rest of the $12 million building. And we get the file 2.5 years after the loss. The building is rebuilt. Everything is gone. And we have an expert from a CFI who is not qualified to testify as to the cause. His or her testimony might be great to pinpoint where the fire started, but that person is not a cause expert. They are an origin expert. So this mistake that we talk about in the article, 10 subrogation mistakes, really cautions client about a practice of rushing into broad agreements with experts, and I put that word in quotes, vendors who come in and offer cut rate fees, sliding menu of services. Yes, we're nuclear reactor experts. We also are experts on bicycle manufacturing, brain surgery, and just about any other area you want. And, they claim to have a bevy of experts across a broad spectrum of technical areas, only to find out that they don't. But that's who the client hires, because maybe upper management said, well, I think it would be a wise idea if we had an in-house or a contracted vendor for experts that we can use for everything. When the most important thing is hiring the right expert. I'm sure you've seen cases where multi-million-dollar losses are reduced to nothing but nuisance settlement value because the evidence is gone and the expert we have, if we have one, isn't qualified.
And we have to deliver the bad news. And that's the hard part there is, I had one it was just a few weeks ago, actually, came in, multi-million-dollar cat loss, fire claim. It was in a breaker box. Client, hired an origin and cause expert, so the O&C, which would be just the certified fire inspector. They went out there and they said, oh yeah, no question, fire originated in this panel, likely due to some work that was being done by a prior contractor. Okay, that's all they did. They released the scene, everything's cleared. That's all you got, right? I have to look at the case. I'm telling the client, hey, that's not enough, right? I mean, you have a perspective on origin, but we need to have an electrical engineer, somebody who can go out there and give an opinion as to exactly what occurred, why this arcing event happened, and so forth. So it's really hard news to deliver to clients when they're sitting here saying, hey, we got this slam dunk amazing case, and we have to come back and say, hey, you needed to do a joint scene exam, right? The defendant had never had the opportunity to get out there, right? Your certified fire inspector, I mean, excellent guy, but he doesn't have the requisite ability to testify as to cause on this case. He's an origin expert, and that's a huge thing. And it really takes, if there's one piece of advice for newer adjusters, newer people to retaining experts, that's the first one. It's really understanding the type of experts in the business. It's being able to distinguish between the two. I mean, as simple as, knowing the different, acronyms, the different type of engineers, right? We have origin and cause. We have mechanical engineers, right? We have electrical engineers, right? Another big thing is on failures, trying to figure out pretty early on. Oftentimes we work with our origin and cause, our fire expert, to determine who's needed next. Is it an electrical or a mechanical engineer? Frankly, sometimes we need both. That gets pricey. Other type of engineers. I mean, we have structural engineers, civil engineers, manufacturing engineers, systems engineers, safety engineers, architectural engineers. We have architects. Sometimes we don't need an engineer. We need an actual architect when it is based on the design and the plans. Chemical engineers, material engineers. Lots of engineers. These cases can be expensive. Sometimes we need one. Sometimes we need many. But in the end, it's recognizing and realizing that we need to find the right type of engineer and then that right individual, right? You need to interview the people because ultimately, Gary had mentioned it. I mean, the jack of all trades experts, that's can be just fine in general for origin and cause for that initial fire inspector, right? Because they're looking at burn pattern analysis. They're pointing towards where the fire originated. But when it comes to the specific expert looking at that loss, we want to make absolutely sure that they handle this type of claim. I've seen a number of cases where clients, they refer it over, oh yeah, we have a mechanical engineer. Mechanical engineer looks at this, dehumidifier fire. Then we find out looking at his resume online and talking to him, oh yeah, this is the first fire case he's handled in 6 years. Otherwise, he just handles supply line failures, right? That's not who you want to use, when you have a cat loss. So being very specific, avoiding that national vendor game, right? There can be some, ultimately, I can think of 5 really good expert engineering firms who are best in class, right? There's a lot of very poor engineering firms as well. So that's not me saying don't use some of the top name firms. You should, but you should be selecting not based on the name of that firm, but based on the specific merits, background, education of that expert.
Agreed. And a second cousin to that topic is there are some expert firms out there who get their foot in the door by saying, look, we're going to charge you, $125 to do an initial, review or some outrageously low amount. And you get a report that they might call a level 1. And level 1 really doesn't involve any palpable scientific testing. It doesn't involve the scientific method. It doesn't really involve inspections, destructive testing. It's looking around and giving your first impressions and observations. And those are important, obviously, recording, memorializing what you see in detail by somebody who's qualified to do it is important. But all of a sudden, you are looking at a case that's 2 years old and you need not a level 1, but a level 5. You have to get into the nitty gritty and find out why this particular apparatus or mechanism or machine failed, or why the chemical mixture caused an explosion. And you don't have that. So yeah, when you mentioned pricey, it made me think of something, and that is there are cases where you do not want the best experts. And knowing which is extremely important in successful subrogation. For example, if you have a case where the damages are $35,000, but you will need an expert to prove your case, and the third party is not going to pay a dime unless they see a report or some indicia of an expert opinion that says they are responsible due to negligent maintenance, repair, design, production, manufacturing, marketing, whatever. And you now cannot afford the type of experts that would be required on a much larger subrogation case, but the case is worthless without an expert. So in those cases, yeah, let's go get the jack of all trades, and for a minimum price, you may be able to get an opinion that can get you a settlement. It's a judgment call, and it's one which benefits greatly from experience, both claims experience and subrogation counsel experience. So I think that's very important.
Right. And like I've said in almost every podcast that I've done so far, one of the big points I always make is you can't treat subrogation claims or just cases in general the same. There's no templatizing this. Every case needs to be treated differently based on the facts, the amounts at issue, the geography. And that is absolutely with a huge exclamation point for products cases, for cases that involve experts. We might want to find somebody that's just, what's the cheapest expert we can find to be able to prove the minimum elements of our case. Or it could be other cases. I can tell you, I deal with a lot of very large loss truck fires, right? Because I represent a number of motor carriers and insurance carriers for commercial auto carriers or motor carriers. And in the end, I have one guy who I love to use, mechanical engineer. I will fly him out all around the country, right? It costs a little more. We're paying an extra $1,500 probably in total, right? He also has a decently high hourly rate, but he is best in class. And also another perspective on that is I know in the end, when we're all done, all said and done on that case, when we look at expert expenditures, even though his hourly rate is higher, even though I have to fly him out there, he's not having to research these issues. He's not charging us for redundant work. He is putting, 1 hour of his time is 3 hours of somebody who doesn't handle these type of fires time. So it's important just to look at those things, right? Geography can be key. I think too often clients rely on geography for retaining experts, like who's local, right? Ultimately, that may be the case for smaller losses. That may make sense in many situations, but it's oftentimes the case with very, you could say, technical or claims involving things that are unique, that require special expertise. Do not hesitate to find somebody from somewhere else in the country, fly them in for a day. It's not that big of a deal. And we do it all the time, when the case justifies it.
Yeah, it's hard to have a rule of thumb with regard to that. But one of the sort of guidelines I follow is if you have a case that's $100,000 or less, ask for an expert within that state. You're not going to have the travel costs, the airfare, hotels, meals, yada, yada. And ultimately, it's going to be much more cost effective. If you have a case between 100,000 and say 500,000, it becomes a little dicey. You may want to look in 5 states surrounding area. Again, it's a lot more expensive to have experts come in for an initial inspection. Then they fly back in for a detailed destructive examination. Then they fly back in for a deposition. And guess what? They fly in for a 4th time for a trial, which could last a long time. So airfare, meals, transportation, lodging, not to mention sitting around time. Many of these experts will charge for having to travel and sit around and do nothing and not work on other matters. And we're talking significant experts fees. But if you have a case that's, $1 million or more, don't even worry about geography. If you have to have an expert fly in from Berlin, do it, because it is more important to have the right expert than to save a few $1,000s on airfare. Absolutely important in that regard. Now, I will say that because we have these concerns, we have, by we, I mean Matisse and Wickert and Lair has gathered and put together an expert database of some 10,000 experts over the course of 40 years. As experts die or they become disqualified. If an expert is disqualified by a court, and we can talk more about that in a second, generally that's a black mark because they could be disqualified again. And you could pay a lot of money for an expert, only have to have the judge say no dice. He's not going to testify about that because he's not qualified. So you can have those kind of considerations as well. But I think understanding that it's important to get the right expert, and that's why we have our database, in the right discipline, and that has to be cataloged and searchable, in the right geography. You've got your sub $100,000 case, you need someone in Idaho. Or number 4, the right price. In large cases, it's no concern, but in many, many cases, in most cases, it is of some concern. So, and then I would say the 5th and perhaps the most important characteristic of an expert isn't how many degrees they have, isn't how many cases they've handled. It isn't whether they work for the plaintiff or the defense. And side note, yes, it is good to have somebody who switch hits, because the defense can't say, this guy has testified in 193 cases, all for the plaintiffs. He's a plaintiff's expert. He's bought and paid for. And he'll say anything if he's paid to say it. Whereas if you have an expert who's more balanced, 70-30 plaintiff or, 60-40 defense, this expert has a lot more credibility with the jury who says, hey, a lot of times he comes in and finds no defects. He finds nothing wrong. So that's important. But the 5th characteristic I was going to mention is, and you will not know this unless you go through us for your expert, and that is the intangible, rare quality or skill of being able to testify in a cogent and persuasive manner. We are in the persuasion business. And I can tell you real quick that some of the most expensive and qualified experts you could ever find, if the world was going to blow up and Congress had to bring in the top minds in a certain technical area, these guys would be there. But they cannot testify without getting ruffled by cross-examination, without losing track of their train of thought, and without effectively educating and leading the jury to water if their life depended on it. So, a few tips that we have for our experts are, always tell the truth, even if it hurts. Don't be pompous. Don't be egotistical. Ashton, I know for a fact, and no names will be mentioned, but experts like this who are just so pompous because, they have a master's degree in something and they've been called as an expert, and the attorney challenges them and they become indignant on the stand or in the deposition, making themselves look weak. So don't be pompous or egotistical, and just state the facts. Don't speak down to the jury. Use plain English. Let me ask you a question. I don't know if any of our audience has, but do you know the TV series called Patriot? Does that ring a bell?
No, not for me, but tell me about it, Gary.
Well, it's Patriot is a TV series. I'm trying to think about where it is. It's sort of it's a turbulent and complicated vignette of the life of an intelligence officer. It's funny as all get out. It's set of all places in Milwaukee. And this intelligence officer, whose name is John Tavner, his latest assignment is to get inside this company in Milwaukee which deals with piping. And this is his cover. And so he becomes this non-official cover or a knock. And it's funny as all get out. It's one of my favorite TV series. I've watched it twice. My kids love it. Everyone I know who's seen it loved it. But what he does is he has to come in and he has to learn the lingo. So for an expert, where I say use plain English, translate technical terms when necessary. Here, I actually just pulled it up. Here's a little vignette from testimony of this knock as he's pretending to be an expert. He says, "Let me walk you through our Donnelly nut spacing and crack system rim riding grip configuration. Use a field of half-seized sprats and brass-fitted nickel slits, our bracketed caps and splay flex brace column vent dampers to dampening hatch depths of 1/2 meter from the damper crown to a spurry plinth. How? Well, we bolster 12 husk nuts to each girdle jerry, while flex tandems press a task apparatus of 10 vertical composite patch amplers." Okay, believe it or not, experts will testify like that. And I don't know how quickly it's possible to turn somebody off from a matter of interest or where they have a civic duty like a jury to listening to a witness, but that'll do it instantly. So we also tell the experts, don't be an advocate for the case. Don't try to convince the jury. Just be, a knowledgeable expert. Don't evade cross-examination questions. Don't talk back. Don't be disrespectful to any member of the court. And don't be a show-off. One of the things I do, Ashton, is let's say I have a case involving a defective vehicle. The vehicle was manufactured in such a way that some of the brake fluid lines were too close to another moving part in the engine, which was able to rub them, and they leaked and started a fire and it burned up the car. Or you pick your product. I will sit with that expert and I'll look him in the face and I'll say, listen, I am going to ask you a question on the stand. Do you have an opinion based on reasonable scientific certainty as to whether or not this 2017 Cadillac Escalade was defectively designed and unreasonably dangerous, and whether that was a producing cause of the fire and the damage that we've seen? And I want him to respond with yes. Not a soliloquy, but a simple yes. Then I will say, what is that opinion based on reasonable scientific certainty? And I will stop him and I will tell him what I want him to say. Then I will say, look, you are here to tell the truth and you are not to deviate from the truth. You are here to give an opinion, but understand that an opinion doesn't mean it has to be 100% certain. It just has to be reasonably certain. And are you able to repeat back what I just told you? And I make them do it. And then I'll make them do it again. And just like training, like training a dog, your expert can be trained. So I don't know what his experience is sometimes on the stand when confronted with tough cross-examination, but I want him to stick with those words. So that's something that I do quite often. I don't know about you.
Yeah. And I'd say for the audience and for everyone listening today, first off, thank you, Gary. We got a great television series recommendation. I'm looking it up, 91% on Rotten Tomatoes. I think that's good. I guess that'll be added to my list. Things I can do when the new baby's born. For those that don't have a baby, another Another one, my fourth coming on end of August. So that'll be added to my list. Duly noted. But I agree. I mean, I think the biggest thing we can do is when we talk to those experts, I think as we've kind of pressed into everyone's mind, it's to interview them. It's to have those conversations. I mean, we're not going to know as much as we need to know, right? Your questions are essential whenever any expert is actually going to trial or being deposed. But we can get a lot of information just from initial phone calls. You can suss this out pretty well, right? We could tell who's going to be obviously most engineers are going to be relatively bookwormish, and that's good, just like lawyers. But we can also tell who has those communication skills, who has that ability to connect interpersonally. I think that's an important factor on any case where we expect it to go through and into litigation. Now, speaking of litigation, Gary, I think we should talk a little bit about qualifying experts, Dober standard, and kind of issues we see and why it's so essential that we retain the right expert that can be qualified as an expert in the given litigation. Gary, you want to touch on that a little bit?
Sure. Just 20 seconds of quick history. Not too long ago, there was no guidelines. There was no parameters. There was no safeguards against somebody coming in and just providing absolutely bizarre opinions. The earth is flat, which is why I mentioned that one mistake in that article we call the Flat Earth Society. So you have to, but over time, junk science, and that is a popular term now, but junk science has been on the minds of Congress for purposes of federal rules, and in all state legislatures, states have moved at different speeds and for different reasons toward narrowing the qualifications that would allow someone to testify and give an opinion. And just as a matter of housekeeping for lay people, when you testify in court, if you don't have personal knowledge of something, you cannot testify to it, or it's rejected as hearsay. TV shows you'll say, objection, Your Honor, hearsay, sustained. Okay, you can't testify, jury can't hear it. Opinion is a type of hearsay because if I have an opinion that vehicle was traveling at 136 miles an hour, well, how do you know that? Well, I saw it. Well, did you have a radar gun? How do you know it's 136? Courts have gradually tamped down on the ability of people to come in and give their opinions. Yes, I think that this Black & Decker drill was defectively designed and unreasonably dangerous. Well, why do you think that? Well, it blew up and took our employee's eye. Well, but what makes you think it was defective? It blew up. That's not going to wash. Throughout the 20th century, junk science has been under attack, and American courts and legislatures have made a lot of efforts at sort of reforming the business of selling forensic opinions that are not based in true sound science, aka junk science. We go back to as far as 1922. There was a case involving the murder of an African-American gentleman down in the District of Columbia, and the court disallowed introduction of a lie detector test that proved the innocence of this defendant. Defendant was found guilty. And on appeal, it was held not to be error to allow the lie detector test because it had some scientific certainty and veracity. That was a case called Frye versus United States, FRYE. It is the first case, 1922, criminal case, by the way, where the courts have said, we are now going to be the gatekeeper of which experts can testify. We will have hearings outside of the jury. The expert might go on the stand, and we will find out whether or not the testimony he or she is going to give is based on sound scientific theory. It can be tested with the scientific method. It's a matter that's used throughout the industry. And so the Frye standard now determines whether or not the method by which the evidence was obtained is generally accepted by experts in the field. That was the original test. We went from 1922 until the 1990s when there was a case called Daubert versus Merrill Dow Pharmaceuticals. And that was in 1993, which held that Rule 702 of the Federal Rules of Evidence, which is called testimony by expert witnesses. The Daubert case held that that did not incorporate the Frye standard, but that the rule incorporated a flexible reliability standard instead. So it sort of opened up that the witness must be qualified as an expert by knowledge, skill, experience, training, or education, and only if the witness has done that may he or she testify and provide an opinion. And then after Daubert, in 1997, there was another case called General Electric versus Joyner, and that was a case. There's three cases called the Daubert trilogy, and these are three U.S. Supreme Court cases, by the way. And Joyner held that a district judge can exclude expert testimony where there are gaps between the evidence relied on and that person's conclusion. What does that mean? Everyone in the audience has heard of chain of custody. When you have a product that is defective, you must be able to trace the product that was bought at Ace Hardware by the insured all the way to the accident, to the hands of the investigator, and to the courtroom. If not, there is a gap in the evidence, and the court may disallow it because those are all items of proof. And the last case was in 1999 called Kumho Tire versus Carmichael, and that was the case that established sort of where we are today, that the judge's gatekeeping function, which was identified in Daubert, applies to all expert testimony, including, and this is important, non-scientific expert testimony. So both traditional scientific and non-scientific experts are governed by these requirements, this gatekeeping standard. Just quick example, non-scientific expert, what the heck does that mean? Well, it could be a therapist. It could be somebody who gives an opinion on speed or temperature, or it could be any sort of medical testimony, giving an opinion on medical condition. So that's sort of where we are today, Ashton. And it's important that our clients remember that there is a gate that if you hire an expert, and going to some of the big expert houses is absolutely fine. But if you have an expert and you send us that case, that expert is wed to that case. Unless we have all of the evidence, we can't go out and get a new expert if this expert isn't qualified or isn't appropriate for the case. So just remember that when you hire an expert, you are either moving the case forward or consigning the case to a slow death based on the expert you hire.
And be careful because, I mean, Gary, you made the point that it's really hard to bring in a new expert. I had a case last year where client retains this materials engineering firm to look at its PEX piping to figure out if it was appropriately manufactured. It was a components materials analysis. And the expert I spoke to on the phone, frankly, I spoke with this firm, this materials engineer, and I could just tell the guy had no idea what he was talking about. He also, to be honest with you, he spoliated the evidence. He didn't even notice up a joint lab exam. He just said, I'm just going to test part of it, and cut off a big piece of this pipe, tested it, found that there was a particular material on there that causes deterioration from an external source, right? Making our case very difficult. Well, then we had another expert take a look, and they reviewed it. And, you know, the other expert said there's no way that this material is on this PEX piping. They were just wrong. It could have been an issue with their lab. It could have been they didn't know how to test. Either way, but in litigation, the scary part there is we have to disclose, and we're going to have to produce in most jurisdictions that prior expert's opinion, even if we bring in a supplemental report, even if we have another expert. So there's a lot of things, as we move forward. There's some miscellaneous advice I want to give as we kind of move on and wrap up this podcast today. It's the idea of communicating with experts. One piece of advice, we need to tell them which side we're on. Ultimately, these aren't hired guns. Most of our experts, as Gary said, they're going to tell the truth. We want them to tell the truth. But frankly, sometimes they look into things in different ways. I've had experts where they didn't know they were on the subrogation side, and they come to us with a smile on their face saying, yeah, there's no way we can prove this case. You're good, right? Liability, there's no liability on this part. It's like, oh, well, hold up. We're subrogation. We were hoping to find a viable case. And then somehow, they step back. But either way, we always want to tell them who we are, what we're doing. Also, other piece of advice, and I assume you agree with this, Gary, we want to avoid, in almost all situations, written reports prior to the retention of counsel. So I hate to see a case that's going to move into litigation where the client asks our expert, our engineer, to write a written report. Reason being, we want to be involved with that, right? We may see things that need to be looked into further. We may need to have some supplemental review, an additional lab examination. And upon the release of that report, that is going to be evidence that needs to be produced. So we can't just supplement it and solely produce a supplemental report in most jurisdictions. Anything produced needs to go forward. And ultimately, you want to allow your counsel, your attorneys, they may see things and have certain strategies and approaches to ensure that that expert writes the report with truth, but also in some significant, some particular manner. You agree with that, Gary?
Well, yeah, not only do I agree with it, but one of my favorite tactics, because remember, there are two sides to a subrogation suit. There's a plaintiff and there's a defendant. That we're talking about the plaintiff's experts proving liability. The counterpart on the other side, they're also hiring their experts. When we talk about prompt action on subrogation, remember, the moment an accident happens, the other side is already garnering their war chest. They're enlisting their army, and they're getting ready. They've got their experts, and their experts are experts they use over and over and are very, very familiar with the product or the subject matter of the loss. But one of my favorite cross-examination techniques, and destroying the defendant's expert is just as important as us building up our expert. One of my favorite cross-examination techniques is when the defendant has written a report, like Ashton was describing. Early on, I will pull that report out. Is this your report, Dr. So-and-so? Well, yes, it is. I see it's dated, 2017. Is that correct? Yes, it is. And this accident happened in 2016, correct? Yes, sir. Well, I assume then when you wrote this expert, you did not have any of the information that was divulged in the inspection in 2020, or the additional information garnered from these witnesses for the first time in 2021, and et cetera. And the expert has to say, no, that report was written without that information. And I said, being an expert and wanting to be as accurate as possible, wouldn't you have preferred to have written this report after you had all that subsequent information? There's no getting out of a bad answer to that question. If they say yes, suddenly the jury looks, well, then that expert report isn't as good as it could be. And if they say no, it makes them look like they don't care and they were just tunnel vision to write a report that said their client wasn't negligent no matter what. So that's a very important point, Ashton.
Absolutely. Good tip. So miscellaneous tip 2 that we have here is being very careful with communications with experts, whether you're the attorney or definitely if you're the adjuster, because by putting things in writing, oftentimes and in many jurisdictions, that correspondence will have to be produced to the other side in discovery under broad-based discovery rules. So we always advise our clients to be very careful of any conversation with the experts and to, as much as possible, have oral conversations with your experts rather than have them asking, I have some clients where they're going back and forth, they're putting bad facts in writing with the expert, And ultimately, that's not your attorney. If it's communications with counsel, that's privilege. There's no real expert client privilege that doesn't exist there. So we always just caution our clients to be very careful, keep expert communications oral as much as possible, similar to the written report side.
Right. That absolutely. And remember that everything that expert has is admissible. If I have one piece of advice for a client who's come across a brand new loss and has listened to this podcast and is going to go get an expert because they want to recover back their money, that piece of advice would be very, very careful what you send that expert. If you send him something from your claim file that is work product privileged, maybe it's not favorable, maybe it's an employer alleging that an employee may have done cocaine, or, because employers sort of rush to blame the employee thinking that they're going to be sued before knowing that they have, an exemption and exclusive remedy protection. That information will be discoverable because it was in the expert's file. Anytime you send an expert anything, imagine whatever it is you're sending being blown up to a 3-foot by 4-foot display board and put in front of a jury to sit there for 20 minutes while an expert is testifying, because that can happen and does happen.
Exactly. Similarly, tip 3, be careful when there's also underlying coverage disputes. We see this quite often. Before subrogation counsel is engaged, or before even sometimes the subrogation team is brought on board, I'll see insurance carriers engaged in a coverage analysis. They retain their own experts, or they're reviewing this, and they're really putting in ultimately the coverage dispute goes directly against, right? And it can be oftentimes in opposition to that future subrogation claim. So anytime that comes up, I advise my clients, if there appears to be viable subrogation, but there is a coverage dispute. We had this recently on a large case involving a seismologist and whether or not damage to a foundation was caused by a jackhammering event on a construction project, or whether it was just settling. The expert report that they had on the coverage issue ended up being incredibly detrimental to the subrogation claim. So we always say on those cases, just bring subro counsel in immediately, as soon as possible, so that we can try to work to limit that, right? We can't always, tell coverage counsel, hey, don't bring this expert in. But sometimes we can work with those attorneys, work with that team to make sure that at least we're preserving our subrogation claim as best as possible.
Right. One other thing that sort of portends that working with an expert is like painting a picture. And it is an art. For example, when you have a loss and you have witnesses, I looked over and I thought I saw the defendant driving fast, but I'm not sure if it was his car, it was a black car. Or, you might have hearsay evidence or other inadmissible facts that you are not allowed to introduce during a trial, even though you want the jury to hear those things. You may be able to get those in front of a jury through an expert. Informing their opinions, experts may rely on facts or data, admissible or not, as long as it's the type of information that experts in that field reasonably rely on informing opinions on that subject. So I'm saying you can be an artist and actually get evidence in front of a jury in an expert report that otherwise would be inadmissible. And that can be a very powerful tool as well.
Absolutely. Tip 4, undetermined fires. This is a huge factor because I think it's a number of our top recoveries with our firm have been on cases shut down for marked no recovery, no subrogation potential, that we've been able to come in and bring in huge recoveries for clients on. And this is one thing that I just need to note. And it's the idea that a lot of clients will look at this and see a fire report, a fire marshal report, the local FD, and it'll say the fire is undetermined. And they'll say, undetermined, no subrogation potential. I just want to say right now and make clear that is not the case. The fire department, the marshal, they're often looking to see if there's been arson. So the determined nature, the fact that it was undetermined, is largely saying that they couldn't determine if there was arson or not, right? That there's no pointing to that and or other factors. They're not forensic engineers. They're not certified fire experts in almost every situation. So anytime you have a fire that's undetermined, that doesn't mean shut down the case. That means take a look, and if the case justifies it, get in the right experts to take a look, because we cannot rely on fire departments to do forensic reviews. They're not looking for the same thing. They really don't care about whether it was the dehumidifier or the refrigerator that caused the fire. They're just looking to see if somebody else is at fault, as in for arson.
Right. And along the same lines, and I can't tell you the number of times this has happened. I'll receive a large, and by large, I mean mid seven-figure fire loss involving multiple buildings and contents and maybe even cargo. And I'm looking in the file, and the first thing I look for is that expert communication. It may not be a report, because most of the time our clients will have a report and tell the expert to write a report because they have to justify to their supervisor why they just spent $3,700 on this expert. Well, look, here's his report. That's what we paid for. Well, you've just devalued what you paid for when you have a report written, as Ashton just described. But when you have that report, it's important to make sure that you wait for the report and talk to subrogation counsel before you engage someone to write the report, because I've looked in those large mid seven-figure cases. I flip through, and it's amazing how fast you can flip through 5,000 pages of a claim file looking for an expert report, and then you find one. Oh man, this is huge. It's detailed. There's photos, there's diagrams, there's red arrows. Then there's a conclusion. Yes, and I look at the conclusion that said the fire is accidental. Well, of course it's accidental. And again, to Ashton's point, you have hired an expert who may have thought that his sole role was to determine whether or not there was arson, so the claim could be denied. But in fact, you should also be saying, and by the way, if you can come up with an opinion as to the origin and or cause, I mean, let me know. I often tell experts, hey, Mr. Expert, this is what I want you to find. I want you to find that the defendant did this, and it was, and I go through the whole list. And then I say, now understand that you're going to do what ethics lead you to do, and you are not going to lie, and you're going to follow rule number 1, which is tell the truth. But I've already clued him in on where I want him to go. And he's only human, or she. And if they want to be hired again, they know that, hey, I want to please this person. So opinions are, well, you know what they say about opinions. Everyone has one. And opinions are powerful in subrogation litigation. So we want to shape that opinion from the earliest point possible.
Agreed. 3 more tips to quickly go through. 6, don't send evidence to defendants for testing unless the case is absolutely not viable for litigation. Far too often I have clients that have a fire loss and like, well, yeah, it was this lithium ion battery. It's like, we sent it to the defendant, but they don't know where it is now. Or they said that they did testing and they said there's no defect. Well, at that point in time, we've authorized them to test it. The evidence has since been changed potentially by them. Our expert didn't participate. So we always advise clients against sending evidence for testing unless there will be situations. I just had a case maybe 2 months ago where it was a $15,000 loss involving a battery pack for a powered screwdriver, I believe it was a powered drill. And frankly, we didn't have the facts to litigate the case. So I said, hey, rather than close it, we can send it off. Fine. They're asking for it. We'll send it. And manufacturer did come back with an offer at, I think it was about 50% of the loss. So viable way to do it, but just be very careful. Next one, be careful and avoid non-refundable retainers. This is just a practice issue that we've seen clients burned on too often. Experts are getting sneaky. The big reputable firms, they're never going to charge you a non-refundable retainer. But read those contracts, because we've seen clients have come to us and asked us to help defend them against these atrocious expert fees. We're like, oh yeah, it's going to be about $10,000 for the budget. They're used to getting that. But then you owe us $10,000. And then, oh, well, next thing you know, they realize, oh, we actually don't need the expert. Well, that expert has put zero time into it, but they're just keeping the $10,000. So this is happening more and more in the industry. Practice tip, be careful. And finally, final tip I have for you is take the time, have the patience to take steps to retain evidence, not just the evidence, right? And we have other podcasts on evidence retention and setting scene exams, but I encourage everyone, make sure your expert isn't just taking the place, that specific microwave that caused the fire they believe, but also everything around it. Anything that could tentatively be available, because we don't know what is going to be relevant until we know what is going to be relevant. Anything to add there, Gary?
I would just add that a lot of times our clients will send the evidence to the defendant because they are told, at all costs, try and settle this yourself. If you send this to subrogation counsel, they're going to take 25% or a third, and you will make much more money if you can get this thing resolved yourself. And so what they'll do is they will send it to the manufacturer. And then what they tell me is, well, don't worry, because if they lose it, it's spoliation and they're liable. Nothing could be further from the truth. We have a chart on our website called Spoliation Law in all 50 states. And you can take a look at it and see that there are very, very few states that have an actual cause of action for spoliation. Most of the time, there's minor instructions that can be given, or nothing at all. So don't think that just because the defendant gets a product and it's gone, or even if it's lost in transit, that somehow you can recover now through spoliation. That will not work.
I agree with you there. Well, I think we've filled up the full hour with fascinating information. Gary, as always, I appreciate having you on with me. It was excellent. The audience, thank you. Gary, you going to join me again one of these days soon for another podcast?
I have a feeling I will. Thank you, Ashton.
And I understand that Gary's offered to also, step in and host a few of these podcasts for me. So coming up soon, you might hear from the Gary Wickert as the host for Subrogation Support Network. But excellent. Well, I appreciate it, Gary. Everyone, another great episode of the Support Network. Thank you all. Have a great day. And until next time, this is Ashton Kirsch signing off with the Subrogation Support Network podcast. Thank you.